What I have to say is very brief and very net, and I want to talk about sentencing corporate offences and in particular sentencing companies and the issues that arise in relation to that and the potential remedies that may be available having regard to what's available in other jurisdictions. In sentencing law generally in Ireland, we have adopted the approach of judicial discretion in imposing sentences. So the approach here is epitomised by the comments of Chief Justice Finlay in the Tiernan case, where he said, having regard to the fundamental necessity for judges in sentencing in any form of a criminal case to impose a sentence which in their discretion appropriately meets all the particular circumstances of the case, and very few criminal cases are particularly similar, and the particular circumstances of the accused, I would doubt that it is appropriate for an appellate court to appear to be laying down any standardisation or tariff of penalty for cases. Ireland is very much at the other end, not a completely unfettered discretion, but we've repeatedly, in decisions of the Irish Supreme Court, firmly put ourselves in that end of things. Initially, in relation to companies, it was thought that a company could not be guilty of a crime. A company has no mind and therefore cannot have a guilty mind. As an 18th century English Lord Chancellor put it, did you ever expect a corporation to have a conscience when it has no soul to be damned and no body to be kicked? One of the most important decisions in relation to sentencing companies in this jurisdiction is the 2015 decision of Mr Justice Edwards in the DPP and Cavan County Council and Oxygen Environmental Limited. A company and a local authority are both prosecuted, plead guilty and sentenced for the disposal of waste at a landfill in Cavan over a protracted period of time. As a principle in sentencing law, deterrence is an important principle, imposing a penalty that will deter both that defendant and others in the community generally from offending, and will often involve the setting in the case of a company being prosecuted of a fine at a very high level. Another significant innovation is what are described as corporate programs. Now, in the US, there is a legislative basis both at a federal and state level which encourages companies to establish internal compliance and ethics programs. The limitations of imposing only fines on corporate offenders are that the penalty can often be paltry and not enjoy the public confidence that it should. Innovations such as corporate probation, community service and compliance programs have the potential to be more effective tools in sentencing corporate offenders, and maybe this could provide food for thought for perhaps the Sentencing Guidelines and Information Committee of the Judicial Council, or perhaps more appropriately the Minister for Justice in the presence, or perhaps more realistically in the next stall. Thanks very much.